this work with great urgency. For example, just a few months ago, the department secured lengthy prison sentences for 6 white officers from Rankin County, Mississippi, who were convicted of 13 felony offenses. Instead of fulfilling their duty to keep their communities safe and apply the laws of Mississippi fairly and equally, they tortured and assaulted 2 Black men who could not defend themselves or escape the abuse. These officers, who labeled themselves the Goon Squad, arrested the victims without probable cause, detained them unlawfully, abused them violently while using derogatory racial slurs, and stole their personal property. This abhorrent course of conduct culminated with one defendant forcing the barrel of his department-issued firearm into the mouth of one of the victims and pulling the trigger in an attempt to scare him. He did this not once, but twice, and when he did so a second time, a bullet ripped through the victim's mouth and throat and exited through the neck, causing life-threatening injuries. The department held each of these officers accountable and achieved a just outcome for the victims, their families, and the greater Rankin County community. We also secured guilty verdicts for each of the 4 officers responsible for the death of George Floyd, who was killed in 2020 by Minneapolis, Minnesota police officer Derek Chauvin. The jury found that 2 officers willfully deprived Mr. Floyd of his constitutional rights when they failed to intervene in Officer Chauvin's use of excessive force. The jury also found the officers willfully deprived Mr. Floyd of his right to be free from a police officer's deliberate indifference to his serious medical needs by seeing Mr. Floyd in clear need of medical care and willfully failing to aid him. Each of the officers involved received significant prison sentences. We've also charged officers tied to the deaths of Breonna Taylor and Tyree Nichols, and are working to seek justice for their families and ensure accountability. And just 5 days ago, we announced indictments of 2 former police officers from Northwood, Missouri, a town just 4 miles south of Ferguson. We charged those officers with federal civil rights violations. While our criminal enforcement holds individual officers accountable for specific acts, our civil enforcement uses several laws that can reach broader policies and practices. These laws prohibit discrimination on the basis of race, color, national origin, sex, and religion when law enforcement agencies receive funding from the Justice Department. They prohibit discrimination on the basis of disability and prohibit state and local law enforcement officers from engaging in a pattern or practice of conduct that deprives people of rights protected by the Constitution or laws of the United States. These policing cases begin with investigations into allegations of systemic police misconduct resulting from systemic practices throughout a police department or law enforcement agency that violate constitutional rights. When our investigation finds that an agency has unlawful patterns or practices, we usually reach a comprehensive agreement enforced by a federal court to correct the unlawful practices. These agreements, called consent decrees, are designed to support constitutional and effective policing and restore trust between police and communities, and build a culture of non-discrimination and respect for constitutional rights within policing agencies. And these consent decrees can lead to real change. We've seen it in Seattle, for example, where officers use force in less than 0.25% of all events to which officers respond. And in Portland, Oregon, where officers' use of force against people with mental illness is now extremely low, occurring in about 0.5% of encounters. And most of that is the lowest level of force, which does not cause injury. I'll now share with the Commission and with Mrs. Mcfadden and Michael Brown Jr.'s family what I can about two Justice Department investigations: the criminal investigation into the shooting that caused his tragic death and the civil pattern or practice investigation into the Ferguson Police Department. In the criminal investigation in 2015, the Justice Department found that the evidence did not support federal civil rights charges against Ferguson police officer Darren Wilson. In the civil investigation in 2015, the Justice Department found that the Ferguson Police Department engaged in an unlawful pattern or practice of conduct that violates the First, Fourth, and 14th Amendments of the U.S. Constitution. The court entered a consent decree against the Ferguson Police Department, which we continue to enforce today. The federal criminal investigation into the tragic shooting of Michael Brown Jr. sought to determine whether the evidence collected about the events that led to his death was sufficient to prove, beyond a reasonable doubt, that the officer's actions violated federal civil rights laws. Those laws make it a federal crime for someone acting with law enforcement authority or under color of law to willfully violate a person's civil rights. Proof beyond a reasonable doubt is defined as proof that leaves a reasonable juror firmly convinced the defendant is guilty. Defendants act under color of law when they wield power vested in or conferred by a government entity. Those prosecuted under the statute typically include police officers, sheriff duties, and prison guards. I'll note that there are other government actors such as judges, DAs, and other public officials, such as prison transport agencies and prison transport agency employees who also can act under color of law and be prosecuted under this statute. As a part of the investigation, federal authorities reviewed ballistic evidence, forensic and crime scene evidence, medical reports, and autopsy reports, including an independent autopsy that was performed by the U.S. Department of Defense Armed Forces Medical Examiner Service. Officer Wilson's personnel records, audio and video recordings, internet postings, and the transcripts from the proceedings before the St. Louis County Grand Jury. Federal prosecutors and agents interviewed dozens of witnesses to evaluate their accounts and obtain more detailed information. And FBI agents independently canvassed more than 300 residences to locate and interview additional witnesses. The federal criminal civil rights law that we enforce are narrower in key respects vis-a-vis state criminal laws usually used to prosecute criminal police misconduct. The federal laws have no equivalent to the state laws covering, for example, manslaughter or negligence. Rather, federal statutes would require the government to prove that Officer Wilson used unreasonable force when he shot Michael Brown Jr. and that he did so willfully. Willfully would mean proving that he shot Mr. Brown knowing it was wrong and knowing it was against the law to do so. After a careful and exhaustive review of all the evidence, the Justice Department in 2015 determined that the evidence did not establish beyond a reasonable doubt that the officer violated the applicable federal criminal civil rights statute. The analysis of the facts and the law that formed the department's conclusions are contained in a lengthy publicly available report which the department filed with the commission as an exhibit. I understand that this 2015 conclusion gravely disappointed Mr. Brown's parents and family and many in the community. And I ask that the commission and any interested parties read the full report, which shows the thoroughness of the department's criminal investigation into Mr. Brown's death. And while I
Thank you.
understand,
I'm so sorry, Ms. Clark, but the time is up. Would you like to conclude your sentence?
I'll just note that I know that it may be little consolation to the petitioners and others in the family, but I do want to pledge that where there is evidence that supports us doing so, we will continue to pursue charges and convictions against officers who criminally abuse their authority and violate people's civil rights in our country.
Thank you very much. I'm sorry to have to interrupt you, but we are managing our time here. I would now like to ask the petitioner if you want to exercise your right to reply. Now you have 5 minutes, but we will add, I think it's 2 minutes to your time, 7 minutes, having regard to the bit of the run over from the state's presentation.
Thank you so much,
Please
Madam.
proceed.
Thank you so much, Madam President. I'm Wade McMullen, counsel for RFK Human Rights, representing the petitioners and Mr. Mcfadden. We look forward to submitting more thorough response to the state's arguments and our final observations. And we also believe that the written submissions of our expert witnesses will provide further pertinent clarifications for the commission. And also would like to point the commission to the various amicus briefs submitted in this case from the Movement for Black Lives, Mothers Against Police Brutality, the ACLU, the National Police Accountability Project of the National Lawyers Guild, and the Chicago Torture Justice Center. Collectively, these civil society organizations represents millions of people in this country who see the case the way that Ms. Mcfadden does. So while the state has not made many arguments in this hearing, I want to first point to how they listed a litany of instances where they have held police accountable and commend them for the accountability they have achieved in those cases. But I'd like to point out that far from the picture that has been painted here today, police killed 1,300 people last year in the United States, and only 10 officers were charged. That is less than 1%. So far from the picture that is painted, the case at hand, the case of Michael Brown and his murder and the impunity that exists, is far more emblematic of the impunity that persists in the United States today than the case studies that were presented. It's worth repeating that even after 10 years, Officer Wilson has not faced a single form of accountability, not administratively, not civilly, and not criminally, not a single form of accountability. So I'm going to direct the rest of my remarks to the arguments the state makes in the brief that they submitted as a part of their presence here today for the hearing, and address some of the DOJ report that was just detailed. In this brief, the state does make arguments and several assertions in particular that it has taken actions to either remedy or cure an underlying human rights violation in this case. Notably, the family civil suit settlement, the DOJ report, as we've just heard, and Wesley Bell's review of the case. Interestingly, the state does not seem to argue that the McCullough investigation and grand jury process fulfilled the state's international obligations. The state argues that even if the McCullough investigation constitutes a violation in the eyes of the commission, that other state actions that they've taken remedy or cure that lack of due diligence and accountability. In response, petitioners first reiterate that if the McCullough grand jury process was indeed flawed, as we have demonstrated, that alone is sufficient to give rise to a violation of the American Declaration. Second, where the state argues that these other actions constitute a remedy or a cure, petitioners would welcome a stipulation by the state that there is indeed an underlying violation or violations of the American Declaration in this case. Finally, we would also ask the state to clarify whether it is the official position of the United States government that Bob McCullough conducted his investigation free from bias, with due diligence as required by international law. And we would like that clarification, especially as this stands in stark contrast to the experience of Lesley and her family, to the stark contrast to the experience of the Ferguson community, to the stark contrast to the analysis of our country's top legal scholars and in stark contrast to the collective sentiment of one of the largest social movements, the largest social movement that this country has ever seen. On the civil suit settlement, this commission and international human rights law more broadly could not be more clear. Financial compensation alone is never sufficient to remedy violations of this nature. So I'm going to move on to the DOJ report. The DOJ has admitted in public forums that they typically don't issue these types of reports in these criminal federal civil rights investigations, and that they drafted the Brown report in order to persuade the public. Instead of being evidence of the state's due diligence, we urge the commission to view this report for what it is, either as a tool of public persuasion that the DOJ say they intended it to be, or else analyze its insufficiencies on its face. So as the state recommends that you read the report, so do the petitioners. Because on its face, its inconsistencies are incredible. Ultimately, no investigation with due diligence could result in such a report with such crucial inconsistencies. Not only does DOJ fail to offer any explanation for its inconsistencies, it fails to even identify that an inconsistency exists. And it goes further by relying heavily on these inconsistencies to drive their conclusions in a one-sided public narrative that just so happens to 100% align with the biased investigation of Bob McCullough and the narrative of the racist Ferguson Police Department. Where in the DOJ report does it detail Darren Wilson's use of racist language in his past that they said they reviewed? Where does it weigh Mike Brown's reputation in the community and who he was as an individual, and how that did not comport to the narrative being levied against him? Where does it reckon with the myriad instance where Wilson was furthering the racist patterns and practices of his department in the past? Where in the DOJ report does it analyze Wilson's expletive-laden, violent initiation of an encounter with Mike Brown? Where in the DOJ report does it reckon with the racist treatment of Mike Brown's family by a DOJ prosecutor who led the report's writing? Further, if the DOJ contends that specific intent standard of federal civil rights, criminal civil rights law is not sufficient, then that in and of itself is evidence that the state is unable to achieve accountability, giving rise to a violation in this case. On the Bell review and his decision, it's abundantly clear by now that he never conducted his own investigation, let alone with due diligence. He just reviewed the tainted file he inherited from Bob McCullough. And it's abundantly clear that Bell's decision not to proceed with due diligence and seek accountability rested on his own political decision, not one in furtherance of justice. Ultimately, the state's arguments present some confusion between carrying out an investigation or multiple investigations with carrying out an impartial investigation with due diligence as required under international law. Confusion over having a process with carrying out due process. Confusion over taking some steps towards accountability or ending police violence with taking sufficient steps to meet their international human rights obligations. Ultimately, we have to ask ourselves how 10 years later, that officer who murdered Mike Brown has not faced a single measure of accountability. And that is at the crux of this case. And I thank you for your time.
Thank you very much, Mr. McMullen. And now, the state, you have your right to rejoinder. You also have 5 minutes.
Good afternoon. My name is Sarah Hunter, and I'm an attorney advisor with the U.S. Department of State. Again, I want to thank all the participants for sharing their perspectives with us here today, in particular, Ms. Mcfadden. At this moment, I'd like to turn it back over to Assistant Attorney General Clark for further remarks.
Thank you. I would like to now address our civil pattern or practice investigation into the Ferguson Police Department. Our civil pattern or practice investigation looked at a few areas: use of force, including deadly force, stop, searches, and arrest, racially discriminatory policing, and treatment of detainees inside Ferguson City Jail. In the course of the investigation, the Justice Department reviewed more than 35,000 pages of police records, interviewed various officials, participated in meetings with community members, reviewed data, and more. The department found that Ferguson focused on generating revenue rather than on public safety. This focus, combined with racial bias, profoundly affected the department's police and court practices. resulted in conduct that routinely violated the Constitution and federal law. We found that these patterns also created a lack of trust between the police department and a significant portion of Ferguson's residents, especially Black residents. The findings are laid out in a 100-page report, which we have submitted to the commission as an exhibit. In 2016, the city of Ferguson entered into a consent decree with the Justice Department, which is still in effect, overseen by a federal court and an independent monitor. The consent decree requires reforms in numerous areas, including bias-free policing, stops, searches, citations, and arrests, use of force, First Amendment protected activity, crisis intervention, supervision, municipal court reform, accountability, and community engagement. I'll note that the city has developed use of force policies in line with the consent decree, developed and implemented a use of force database, developed bias-free policing policies, and revised policies on stops and searches, among other efforts. The pace of the city's compliance efforts has picked up substantially in recent months. At a status hearing before the court yesterday, the independent monitor reported that initial results of the use of force audit present an improvement. Our end goal is to bring the city of Ferguson into compliance with the consent decree as soon as possible. We know from our experience that civil rights policing investigations and the implementation of reforms called for by our consent decrees can make a huge difference. Seattle is one recent example. There, the police department changed its policies and training regarding use of force and stops, and has improved its response to people experiencing behavioral health crises, and has instituted policies to ensure bias-free policing. Now, force is used in less than 0.25% of all events to which Seattle officers respond. The police department has reduced the use of serious force by 60%, and there are further accomplishments that we can share that result from this work. I'll note that since January of 2021, the Justice Department has obtained convictions of 180 defendants for charges concerning violations of people's federal civil rights. These defendants were primarily law enforcement officers. These prosecutions demonstrate that we will seek accountability for officers whose actions violate the law. There still is much work left to be done to eradicate racially discriminatory and unconstitutional policing in America, and work to be done to restore public trust. I have met with many families and survivors of police misconduct, and their stories, their pain and resolve strengthen my and our commitment to this work. Often I hear that justice means preventing what happened to their loved one from ever happening again, and we agree with their view. My hope and my goal is that the Civil Rights Division's civil and criminal enforcement work yields meaningful police reform and holds accountable those who violate the rights of people they were sworn to serve and protect. Thank you.
Thank you very much, Ms. Kristen, for that. And now we are at the stage where the commission will have questions for the petitioners and for the representatives of the state. And I go in the same order. I think I will break up the questions in a group of 4 and 3 so that we don't have a long litany of questions. I would like to start with Commissioner Denise, and again reminding the participants here today that Commissioner Denise is the rapporteur for the rights for rights of people of African descent. Commissioner Denise, over to you for your questions.
And against racial discrimination. Thank you very much, Madam President. A lot of words have passed in these 10 years, I think, in dialogue and interventions and proceedings. if I've listened to the reports from both sides, the petitioners and the state, I would say there has been dripped action. And the result of listening to the interventions today is that there has been minimal impact. What I want to ask the state is, did the state adopt legislative measures, both at the federal and state levels, to harmonize its regulations with international law in the area of the use of force and the use of lethal force, observing the principles of exceptionality, necessity, proportionality, and legality? If so, could you please detail them? Second question, did the state adopt any psychological care mechanism for the family of Michael Brown Jr.? The petitioner's questions I will raise at once. Do you consider that stereotypes or acts of racial discriminations were present in the criminal process? If so, could you elaborate on such facts? And what measures or public policies do you think the state should adopt to establish an effective accountability mechanism in cases of police violence? Thank you, Madam Chair.
Thank you, Commissioner Denise. Commissioner Caballero.
Sí, muchas gracias. Quiero dirigirme a Kristen Clark, que la fiscal general adjunta de la División de Derechos Civiles del Departamento de Justicia, y un poco una pequeña digresión del caso, con todo respeto, porque escuché aquí todo el tema de los protocolos, de las actuaciones frente a con la policía en diferentes estados, la contención al actuar de la policía. Pero quiero poner una mirada en el tema de la garantía de no repetición y en el tema de la procedencia de la policía y en el tema de la formación de las policías. Es decir, no sé, yo lo que escuché es cómo se está reconduciendo la actuación de la policía con política pública, con normativa, y cómo se está conteniendo pues toda esta actuación, digamos, para que no tenga estos patrones de discriminación. Perdón que lo diga así, pero no escuché nada sobre la procedencia de la policía. ¿Quién llega a ser policía? ¿Y qué protocolos hay de selección? ¿Y qué protocolos hay de formación de las policías? Porque el tema de la discriminación tiene que ver también pues con un tono que hay de cierta cultura, con un supremacismo blanco, con un lugar común, que a lo mejor es un lugar común y una realidad de esta idea de los varones blancos teniendo la fuerza y el orden, ¿verdad? Entonces, ¿qué protocolos hay de procedencia y formación para que haya diversidad también, integración de las policías, para que haya más mujeres, para que haya diversidad de origen étnico, etcétera, racial? Esa es una pregunta que yo le quisiera hacer a la fiscal Clark. Gracias. Gracias, presidenta.
Thank you, Commissioner Caballero. I will now ask Commissioner Ralón, and then we go to the answers, and then we come back to the last three commissioners. Commissioner Ralón.
Muchas gracias, presidenta. Yo quisiera preguntar a los peticionarios si tienen algún tipo de información estadística específica sobre alguna prevalencia o continuidad de este tipo de casos. También le preguntaría qué políticas públicas considera debería adoptar el Estado para establecer mecanismos de rendición de cuentas más efectivos. Y al Estado, pues le preguntaría el impacto que tuvo el informe del Departamento de Justicia del año 2015. Únicamente, presidenta. Gracias.
Thank you very much, Commissioner Ralón. And so that we don't have a whole sort of pile of questions waiting for the petitioners and the state, I would suggest that we answer these questions first. I turn over to the petitioner. I'm winging it now, but I would say We have about 30 minutes left, so I would say maybe 7 minutes for each, for the petitioner and for the state, and then we have the last 3 commissioners ask their questions. So if we can put 7 minutes on the clock. Well, I'm suggesting 7 minutes, but please go ahead, petitioners. Why they sort this out? We don't want to take up any more time.
Sure, thanks so much. We'll first take the question about was there racial discrimination in this criminal investigation? And my colleague Justin Hansford will start. And then our colleague Deliato Yobo will also add.
Yes, so in this case, there was clear evidence of racial discrimination in all elements of the criminal process, beginning with Darren Wilson's stop, yelling expletives at Mike Brown, encountering him as, according to the police chief of Ferguson's initial statement for the crime of walking in the street. And there is also the admission of Darren Wilson to using the N-word. Darren Wilson's description of Mike Brown as a demon during his statements, and a Hulk-like figure as well. And of course, to move on to the actions of the Ferguson prosecutor, Bob McCullough, the reports have noted his history, which, just to be specific, included the fact that his father was a police officer, as well as his brother and other family members. His father was killed by an African-American man in his youth. And that has been part of the Bob McCullough backstory to explain a number of his actions over the course of decades when it came to providing accountability to specifically the Black residents of Ferguson. And as we mentioned in the federal investigation stage, the fact that one of the attorneys for the Department of Justice mentioned her fear of Mcfadden's statements after learning that her son's killer would not be charged. Those also comport with this idea of a racial trope of Black women being necessarily angered and angry, and fear of the expression of a human emotion in that moment, just is part of the same racial narrative that we see in many cases across the country. And I'll now allow my colleague Delia to make more statements to that end.
Thank you. In regards to the question about the types of the statistics of these cases, one resource that people tend to use is called Mapping Police Violence. This tracks the number of police killings, and within that database, they categorize by, the categories by race, categories is by how many people were stopped, how many people were interacting with the police. But what is notable about this database is that this is not something that is an official reporting mechanism by the actual government. So there is no government body that collects this data at the federal level. So one way to keep track of police violence is to actually track it, monitor it, and that is something that the government falls short in. Additionally, there was a mention of a database that is meant to track misconduct for police officers, but notably that is not something that is available to the public. So for all we know, these officers could be in that database, but move from one police department to another. This is not something that, really shows that the government is really trying to be transparent with the public regarding police misconduct and police violence. And so in terms of, transparency and accountability, those are just two very basic monitoring measures that could be taken.
And finally, in terms of what measures the state should adopt, first and foremost, it has tools at its disposal, as is detailed by the state, to hold officers accountable. And in this case, it's been 10 years and there's nothing. There's many things the state can do. As was mentioned earlier in a question, they can bring the standard authorizing law enforcement officers to use deadly force in the United States. They could bring that in line with the international human rights standard. There's been widespread reporting on this by international bodies, including this commission. There is a doctrine called qualified immunity in the United States. This means that when the family was forced to go through a proceeding, a contentious legal proceeding, in order to receive any type of monetary compensation from the state, that when the state paid the family compensation, they paid them out of taxpayer money. And Officer Darren Wilson, like all police officers who commit crimes in the course of doing their job, are protected by this doctrine, this legal doctrine of qualified immunity. And the state could end that doctrine today by passing legislation to be able to hold officers civilly liable for this types of actions. It's been mentioned that former Attorney General Eric Holder has said that the specific intent element of these federal civil rights criminal laws in Section 242 is just too high, and he wasn't. There's been instances where they were even able to use that statute to prosecute the Ku Klux Klan. And so there's a whole range of measures that they could take place. In addition, there's administrative accountability that could have taken place in this case that still to this day, 10 years later, has not. There is, Darren Wilson is free right now. He retains, there was no stripping of his law enforcement license, and he could get gainful employment at any law enforcement agency in the United States. He could seek that right now. And there's nothing being done administratively to hold him accountable as well.
Thank you. Can I ask the state to give its responses to the questions posed by the three commissioners?
Yes, thank you, commissioners, for those questions. I will answer the questions that I'm able to, and then turn it back to my colleague from the DOJ for her to add to that. I want to start by saying it's an uncomfortable fact of the matter that the racial disparities in policing are unfortunately, in part, a product of the nation's history and culture. So we acknowledge that many of the reforms and efforts we're discussing here today, while important, are alone not going to result in all the changes petitioners seek. Even though we do believe they are a step forward, we are committed to continually evaluating those actions and appreciate the perspectives here today. To the specific questions, I'll leave the questions on use of force to my DOJ colleague, but I wanted to talk a little bit about the question of who becomes a policeman. As you all know, at the commission, we're a federalist system. There are roughly 18,000 police departments across the United States. So we don't have eyes on all of them, that's for sure. We take some of the most egregious cases and look at them and take appropriate action as we can. But at the end of the day, there's some things we can't do given that federalist dynamic. I will note that we did make the state aware of the hearing here today and did not receive an affirmative reply from them. But I will say, so while we can't say about these police departments generally, I will say that there are federal efforts to increase diversity for recruiting into federal law enforcement. And specifically for Ferguson, I will note that the consent decree actually does include provisions on recruiting for diversity specifically, and says, among other things, diversity in life experience, culture, background, race, ethnicity, gender, sexual orientation, and language. As Assistant Attorney General Clark stated earlier, we are still working to implement that consent decree, but that is one of the pieces of it. So we hope, at least in the Ferguson context, to see changes on who becomes a policeman. Sorry. There were some questions about resources for mental health. I'll have to take those back. As far as I know, there weren't federal resources available to this Mcfadden, but I'll need to double check on that and get back to you. I I think now I'll turn it over to Assistant Attorney General Clark to see what she would like to respond to.
Thank you. To Commissioner Caballero's question, I will note that there is another federal law that we use at the Justice Department to address some of the discriminatory barriers faced by people of color and women seeking employment opportunities at police departments and law enforcement agencies. Title VII of the Civil Rights Act is a tool that we use. We've used it, for example, in places like Baltimore County, Maryland, to tear down and eradicate barriers to fair and equal employment opportunities. We want law enforcement agencies that fairly reflect the diversity of the communities that they serve. So I just wanted to briefly note that, and also note that President Biden signed an executive order in May of 2022 on advancing effective, accountable policing and criminal justice practices to enhance public trust and public safety, that contained a number of deliverables, including some of which focus on the retention, recruitment, and hiring of officers, among other things. The president's authority, however, is limited to federal government, and so this executive order applies to federal law enforcement, but serves as a model that can help impact and shape the practices across 18,000 police departments in our country. Thank you.
Thank you very much, Assistant Attorney General. And now we have the last three commissioners to ask questions. And Executive Secretary, if you have a question to ask, please do let me know. But I will start off with Commissioner Bulkan.
Thank you, Madam President. There isn't a lot of time, so I just want to ask one question, and I want to go back to it's really the same question that Commissioner Demise asked, but I'd like to give some context just very briefly. So we've heard a lot from the state about all that's been done in the last 10 years. And I'd like to acknowledge this. And Ms. Clark, I'd like to acknowledge as well your obvious, sincere commitment to justice. So I think that that's a given. But in the context of what you've said and the reality in the ground, I have to point out the reality in the ground, and that there's been a number of independent international reviews of the US justice system in recent years, as well as specifically police use of violence. By this commission in 2019, a very detailed report, Amnesty International in 2020. But I'd like to highlight just the report issued just a few months ago by the United Nations. It was the United Nations International Independent Expert Mechanism, which visited the US. And their conclusions, I should say, were extremely bleak. And the reason I raised this in the context of Commissioner Demise's question is because of their findings, which they said, I only want to highlight two things. They said the report said that Black people in America are 3 times more likely to be killed by police than whites, and 4.5 times more likely to be incarcerated. The report also said that of the more than 1,000 cases of killings by police each year, only 1% result in officers being charged, much less convicted. And so I think what I wanted to highlight is that at the base of some of this lack of accountability are the standards around the laws, the norms and standards about the use of force regulations. And what Amnesty International has said, and what this international UN mechanism has said as well, is that existing local and national standards on the use of force by law enforcement officials, and this includes the Supreme Court rulings and the DOJ's updated policy, do not meet international standards. According to Amnesty International, by 2020, not a single US state had laws that met international standards for police use of lethal force. So I think that this provides some of the context why in 2015, perhaps, or throughout this investigation, there can be no accountability for Michael Brown's killing, because so much latitude is given to the police, and international standards about necessity, proportionality, legality, are simply not met in US law. So I think my simple question to you, Ms. Clark, is given your commitment, given the state's commitment, is there any intention to reform these laws and to harmonize them to reach international standards? Because that's where accountability will begin. Thank you.
Thank you very much, Commissioner Bulkan. Commissioner Puchak?
Muchas gracias, Presidenta, y muchas gracias a las partes por la información proporcionada. Tengo dos preguntas complementarias a las de mis colegas. En primer lugar, sobre la reparación recibida por la familia. Entiendo que hubo un acuerdo de una reparación económica. La Comisión Interamericana eventualmente va a tener que analizar la integralidad de la reparación otorgada, y entonces la pregunta a la parte peticionaria es qué medidas de reparación ha recibido la familia en términos de atención psicológica. Nos decía la mamá de Michael que estaban recibiendo terapia. Esa terapia es pública, es proporcionada por el Estado. ¿Qué atención médica han recibido los familiares? ¿Qué servicios de educación se ha proporcionado a los otros hijos de la familia? En fin, quiero entender qué medidas ha proporcionado el Estado en términos de reparación integral, además del acuerdo económico que entiendo que se otorgó. Esa es la primera pregunta. Y luego también quiero saber cuál fue la reacción pública al más alto nivel en relación con los hechos. O sea, cuando ocurren estos hechos, si existe la sospecha del prejuicio racial y la desconfianza hacia las autoridades, ¿cuál fue la postura pública al mayor nivel posible en relación con estos hechos? Y quiero saber si para la parte peticionaria existió un acompañamiento, se sintieron acompañados por las autoridades públicas, si hubo reuniones, si fueron recibidos, si recibieron un acompañamiento empático de las autoridades políticas de ese momento a nivel local, a nivel estadual, a nivel federal, y que nos cuenten eso, porque eso también forma parte de la evaluación que eventualmente tiene que hacer la Comisión Interamericana. Muchas gracias, señora Presidenta.
Thank you, Commissioner Puchak. Executive Secretary, do you have any questions you want to ask?
No de nuestra parte, Presidenta. Muchas gracias.
Okay, thank you. Okay, so I do have a few questions. To Mr. McMullen, you gave the statistic on 1,300 persons killed by the police last year. Do you have any data on the ethnic profile of those 1,300 persons who were killed by police last year? In relation to, and another question for Assistant Attorney General Clark, in relation to the DOJ's report, we have heard this afternoon a very robust critique of the DOJ report from the petitioners. And my question to you, Assistant Attorney General, is there any possibility of an independent review on how this DOJ report was prepared so that lessons, if any, can be learned for the future? Now, on the question of specific intent, and I think it's partly what Commissioner Bulkan has been talking about, Mr. Hansford, you used the phrase probable cause when you were speaking, and I understood, and you can correct me if I'm wrong, that you were referring to the justification for the use of what amounts to deadly force in this case, the shooting of Michael Brown. So, as I understand it, the use of deadly force is justifiable if the police officer has probable cause to believe that someone who they are deeming to be a suspect poses a threat of serious bodily harm. And my question on this question of probable cause and the belief, is the belief of that specific officer in that specific context? In other words, is this a purely subjective belief, or is there a requirement that a reasonable person in the officer's situation would have believed that there was probable cause? In other words, is there any objectivity to the probable cause belief, or is it purely subjective to the officer or what he says or she says they believe in the moment? And similarly, in relation to the federal criminal law, this whole question again of specific intent, with the question of willingly, that the criminal law must prove that the officer used unreasonable force and did so willingly, knowing it was wrong and against the law to do so. But again, is that purely subjective? That officer knowing, or should a reasonable officer in that situation knowing that the force was unreasonable in the context? So again, for both the question of probable cause and willfulness, what is the test? And is it a purely subjective test? In which case, like Commissioner Bulkan has said, this strays quite away from the international standards on intent and intent in relation to investigation and accountability. So those are my questions for the petitioners and the state. And I know we have about 15 minutes left. I would say, can we say 7 minutes on each side and then we can conclude? So we can start again with the petitioners. 7 minutes. Can we say 6 minutes? 6 minutes. 6 minutes on each side.
My colleague Delia has some information in response to the question on demographic information on the statistics we gave.
Yes. So according to the 2023 police violence report, Black people only make up 12% of the US population, but they were 24% of all killings by police. They also made up 30% of those who were unarmed and killed by the police. So there is a disproportionate, response to police violence and police killings when it comes to those who are Black or Afro-descendant.
And my colleague Justin Hansford is going to address the lack of reparations, full reparations to the family, is asked.
Yes, so the family paid for all of the services mentioned out of pocket. In fact, any state assistance that the family received at the time, public assistance, public housing, all of that was taken away on the grounds of donations that came from the public, taking the family out of the income bracket necessary for being able to receive state assistance in any way. So not only was state assistance not provided for mental health services or any other service, the state assistance that the family was already receiving for public housing, public assistance was taken away. And everything that the family has done for their physical and mental health was paid for out of their own pocket. In terms of the repair and reparation, as was stated, that is something that they're still waiting to receive from the state.
And Madam President, to your question about the legal standard, is the legal standard authorizing the use of deadly force in the United States is not codified in law. It's actually a common law standard developed by our court system, and each state is able to develop different standards up to, raising that bar. But the floor of that standard that you articulated is a subjective standard. That is, we cannot say right now under the current US legal standard that whether it would have authorized that Darren Wilson relied upon to use deadly force. We cannot say that a white police officer with a history of racist beliefs being documented, carrying out an unconstitutional pattern in practice, racially charged pattern in practice of a police department, in a culture that the Department of Justice admits where police officers were texting about President Obama being a chimpanzee and that Black mothers having abortions was, quote, crime control. This was the culture of his police department that he was part and parcel of. And he was a white man who saw a young Black unarmed teenager and saw a demon, a Hulk-like figure, racial tropes that have a sordid history in the United States repeated over and over again. of seeing young Black men as threatening to white individuals in this country. So we cannot, under the current legal standard, say that is demonstrably unreasonable to fear this young Black man based on these racist beliefs and tropes. Under the current legal standard, we are forced to say whether Darren Wilson, with all his implicit bias or whatever racism was baked into that fear, we are forced to say that he subjectively feared. Now, in this case, I just want to reiterate, there isn't complete and utter inconsistency in Darren Wilson's story about why he felt fear that Mike Brown was reaching for his waistband. The evidence does not support this. Even in the DOJ report, they have an inconsistency and credit the wrong hand, the opposite hand that Darren Wilson swears by that he saw that made him fear in that subjective analysis. So to answer your question, yes, it is a subjective analysis. Even in that case, the evidence on the record suggests that it was not even reasonable in that respect. But we are forced to just accept that a racist police officer using unreasonable determinations to feel fear in that scenario, that is baked into the law, unfortunately, at this time.
Yes, one last thing that we did want to mention is that there is actually a piece of legislation that was recently reintroduced this past May by Cori Bush. It's called the Helping Family Heal Act. And basically this would be a piece of legislation that would help folks who have been survivors or victims of police violence access mental health services. And this would be a government funded program. So we did want to note that this is something that is potentially in the works. And something that could offer some form of reparations to those who have suffered from police violence.
Thank you so much.
Thank you very much. And now, representative of the state.
Thank you again for those questions. I want to hit on a few different points. First, I do think it's important to note that the executive order that was recently passed does center de-escalation and requires federal law enforcement to adopt use of force policies that authorize force only when there are no reasonably effective, safe, and feasible alternatives, and deadly force only when necessary. Commissioner Clark, to your question, as Mr. McMullen stated, the test of reasonableness is a judicially made test. And I'm going to quote from the relevant case called Graham, where it says, the question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them. And there's another quote that says, the reasonableness of a particular use of force must be judged from the perspective of a reasonable officer on the scene, rather than with 20/20 vision of hindsight. I hope that gets at your question. As to the official response to these incidents, I think I'd have to refer back to the two reports. Again, one report looked at the killing of Michael Brown with regard to potential criminal liability, and of course the standard for criminal prosecution must be higher than to a more generalized pattern and practice investigation. So the second report involves DOJ's findings regarding the Ferguson Police Department. I think that those are what we'll rely upon for kind of our official response to the incident. I'd also like to note that petitioners are right insofar as additional change needs to happen. We agree with them. Congress needs to take action to ensure lasting, broader change. For one, on the criminal intent standard for prosecuting use of force under Section 242, which is the authority the DOJ has to go after individual police officers. We've acknowledged it's too high. This administration has acknowledged it's too high. There have been multiple attempts to change that standard, but it's something Congress has to do. So President Biden has continued to push for legislation like the George Floyd Justice and Policing Act, which would, among other things, reduce the criminal intent standard from willful to knowing or reckless. At this point, I think I'd like to turn it over back to Assistant Attorney General Clark for further comment.
Yes, thank you. And just picking up on that last point, I'll note that under the current statute, since 2021, we have been able to prosecute 180 defendants for violating people's civil rights while acting under color of law. But the point made about reform efforts and modification of the intent standard is an important one. To President Clark's point, I'll note that we are very focused on the future in Ferguson. We believe that the people of Ferguson deserve nothing less than fair, non-discriminatory, and constitutional policing. And so our efforts today remain laser focused on bringing Ferguson into compliance with our consent decree. There are significant findings made by the Justice Department regarding systemic violations of the law and the Constitution. And we are committed to working with officials, with the city, and with the public to bring about meaningful, lasting, and enduring reform in Ferguson. The final point that I'll just make is that in the past 3 years, the Justice Department has opened pattern or practice investigations into police departments all across the country in cities as large as New York City, where we are investigating the NYPD's Special Victims Division, and Phoenix, where we just issued findings regarding systemic violations of the law. Phoenix is America's 5th largest cities. We have pending investigations into police departments in cities like Louisville, Minneapolis, and Oklahoma City. But it is not lost on us the need to focus on the need for policing reform in small places like Ferguson, Missouri. And it is why we are also investigating small rural police departments like the one in Lexington, Mississippi, where we recently made findings very similar to the findings identified in Ferguson with respect to the imposition of fines and fees on a community that is largely comprised of low-income Black people. I thank you for the opportunity to address you today and send it back to the Chief of Mission, Hastings.
Thank you. Just very briefly, in the minute or so that we have remaining, just to sort of encapsulate, the U.S. government acknowledges the tragic and ugly parts of our history, including our very recent history. And we engage in conversations like this because we recognize that there is room for improvement, and we are seeking to improve. The case today and the issues that we've discussed today are about the actions of certain individuals. They are about patterns in specific police departments, but they also emerge, as we all know, from absolutely systemic, historic consequences of racism in our society and the consequences that those still have today. Changing those things takes time. I say that not as an excuse, but simply to say that it is an effort that the US government is engaged in. It takes time, it takes continual effort. And again, we value conversations such as this one as a spur to keep the US government on task in that work that we all acknowledge we should be doing. I just want to end thanking again Mrs. Mcfadden for her time, as well as everyone else who participated today.
Thank you very much. I just want to reiterate that some of the issues in this case that we've addressed this afternoon and will continue to address surround the adequacy of the proceedings conducted during the criminal process, which would have resulted in a decision not to file charges against the police officer involved. We'll also continue to look at the effectiveness of the investigation conducted by the U.S. Department of Justice regarding the performance of the Ferguson Police Department, and we will continue to consider the existence of alleged patterns of illegal conduct by members of the police. These are some of the issues that we continue to grapple with. We note, however, that the commitment of the state to address the federal state, to address and to redress racialized criminal justice system, and also to get to accountability for disproportionate and deadly use of force. It was, I think, Martin Luther King who said, or he's credited with saying, that the arc of justice is long, but the arc of history is long, but it bends towards justice. But it only bends towards justice if we put it there. It doesn't bend towards justice left on its own. And so in that regard, the work of the Assistant Attorney General and her colleagues in trying to get to, and I'm using your language, Assistant Attorney General, you said to get to fair, non-discriminatory and constitutional policing. This is very, very important. And the positive developments related to the pattern of practice investigations, we certainly appreciate what you've been doing, and we look forward to hearing more about that. But there's a lot to be done, and there is some urgency to it. So long as people are being killed unjustly by the police and accountably by the police, there's an urgency to it. There's an urgency in the moment when people can't walk on the street and feel trustful that they will not be stopped illegally and exposed to harm to their personal integrity and lose their life. So there is some urgency here. I want to thank the representatives of the petitioners, Ms. Kennedy, Mr. Ransford, Ms. Adu Yobo, and of course, Mr. McMullen, for your information and for your passion to this cause that you have demonstrated. I want to thank always Mr. Hastings, Chief of Mission, always very constructively engaged with the Commission, of course, Assistant Attorney General Clark, and Ms. Hunter, again, always assisting the Commission in these hearings. And lastly, on behalf of the Commission, I want to extend our special gratitude to the mother of Michael, Ms. Lesley Mcfadden. We understand the courage and the determination and the resolve that you have to exhibit every day to get through your life and to ensure justice for the death of your son. And the Commission will, of course, impartially consider all of the information it has before it, and we should be issuing a merit report. But before I leave, I would like to ask Deputy Executive Secretary just to outline, especially for Mrs. Mcfadden, what the process is from now until whenever a merit report is completed. What can she expect? What does that process look like?
Gracias, Presidenta. Solamente mencionar, como fue oportunamente notificado a las partes, hay un plazo de 30 días para que presenten sus alegaciones de manera escrita. Con base en esta información, la Comisión podrá tomar oportunamente la decisión respecto de este caso. Muchas gracias, señora Presidenta.
And with that, I thank the commissioners for their engagement, and everyone, I wish you good evening.
Good afternoon. Sorry, we will now proceed to take a group photograph. Okay. If you wish to participate, please keep your cameras on. Okay, we will take the screenshot in 3, 2, 1. Another one, please. 3, 2, 1. Thank you.
Thank you.
Thank you. Good afternoon.
Good afternoon.